and my name is Matt Bellinger, and I'm an attorney. My daughter's on the autism spectrum, so in the introduction when I said I understand kind of what families with a child or an adult child with disabilities are going through, it's because I'm walking a similar path. Not the same, everyone's is different, but she's 26 now, and she's doing really well. And actually, she's the reason why I do what I do. I was a brand new attorney, mid-40s when I went to law school. I was trying to figure out Medicaid waiver services for my daughter. I couldn't. I was getting confused. How could she be eligible for that, but not eligible for Medicaid if I applied for Medicaid directly? Anyway, threw my pen down and thought to myself, I'd have to quit my job and do it full time to figure it out. And I wasn't working at the time, so kind of the light bulb went off. Anyway, so we work pretty much solely with adult children with disabilities and their families throughout the state. And today's talk, what we're going to be talking about is guardianship and the alternatives. But I also have some slides to talk a little bit about benefits that we can just briefly go over that as well, because it's all kind of the same kind of thing. You spend so much time when your child is in school with therapies and figuring out IEPs and trying to navigate that whole thing when your son or daughter's 17, 18, and then you realize, oh my gosh, there's all this other stuff out there. And that's where we kind of try to help. All right, so what we're talking about, let's talk about capacity first. So that's typically the issue that faces most parents. So when your son or daughter turns 18, they're considered to be adults under the law. And they're presumed by law to have the capacity to make their own decisions, even if they can't or even if they need help. And there's two things we'll be talking about, two approaches we'll be talking about, two tools, so to speak, in my legal toolbox at that junction where I can help families. And one is powers of attorney, and the other is guardianship. So first, a little bit about incapacity. It's defined in the Virginia Code. And it's basically the situation where a person can't process information sufficiently to make an informed decision, kind of truncating it. And it specifically says in the statute that bad decisions it doesn't equal incapacity. So it is quite possible to have capacity and make bad decisions. I know I have. But we're really talking about when a person, an adult, or soon to be an adult, can't process information. And like I said, the two avenues that we have to be able to help with that are powers of attorney and advance directives. So let's talk about powers of attorney first. And the reason we talk about them first is not only are they less restrictive, they're easier, and they're less expensive. Less restrictive meaning they don't take away a person's rights. We talk about them first also because the General Assembly has been making changes to the Virginia Code recently, a little bit every year actually. And their focus, what they're trying to tell us to do as practitioners, is to really go with powers of attorney if they'll work. In fact, one of the things we hear about when we talk about guardianship is that they have to be able to show to the court that a less restrictive alternative isn't going to work. So on the slide that we're on now, just to back up just a little bit, so when your child does turn 18, it gets really hard for you to kind of do things for them. Sometimes you can be appointed as their authorized rep. Doctors that know you and your child will continue to work with you, but they'll always be saying, well, we need to do something, power of attorney, or they'll often say guardianship. But it gets a little harder to make even medical appointments for your child. I know when my son turned 18, he's typically developing. You call them, make a medical appointment, and they say, I see your son's 18 now, I need to talk to him. And with him, we would just say, hey, Jake, get on the phone. And you're like, do I have to? It's like, yes, get on the phone. He's 24 now. He makes all his own medical appointments. But my daughter, on the other hand, needs some help. So that's where either powers of attorney or guardianship would come in. They also make their own decisions about education too. So the first time that families often hear about the need for powers of attorney or guardianship is in IEP meetings, because the meeting when you're a junior, like 17 years old, I think it's something that comes out in that meeting. I think they're required, the schools will say something about, when your son or daughter turns 18, you have to consider, how best to help them. Um, and they're not necessarily going to be able to give you advice which way to go, but that's why we're meeting here today. Um, so if you want to go to the next slide, because we will talk about benefits. Go down a little bit more. There you go. Incapacity. So we did that. Incapable of processing and evaluating information effectively, so that they really can't make decisions or meet their safety and medical needs. So you can go to the next slide, and I think that's the power of attorney one. We'll just catch up. Alternatives to guardianship, and this is where we start. So there's really 3 documents that we're talking about here. A durable general power of attorney, which is for like contracts and forms and Medicaid applications, anything financial, is very useful. There's a medical power of attorney, which would be for like making medical appointments, filling prescriptions. Doctors can talk to you because it has a HIPAA release. And there's also a power of attorney for education. And that one is for IEP meetings. Go figure. And with those 3 documents, though, for a young man or woman who has the capacity to sign them, that really kind of gives the parents or the child's agents, doesn't have to be parents, could be grandparents or siblings, the authority to act on their behalf. So power of attorney sets up an agency relationship between the principal, who's the young man or woman signing it, and their agents. And it allows their agents to do things for them, but they don't lose the rights to make their own decisions, and they don't lose the rights to do things for themselves. And most of the time that works just fine. But if they were ever to set their foot down and say, oh no, I'm not taking that class. Nope, no way. You can use all of the skills we learn as parents to get our child and son or daughter to change their mind, bribery, coercion, and just, continuing to talk with them to help them understand the situation better. But you can't use the power of attorney to override their decision. You can't say, well, you signed this means I get to make that decision. And for the most part, in the power education realm and in the financial realm, I don't really see any issues with that. It's more on the medical side where that could become more problematic. So when I meet with families, we talk about things like how they do at the doctor's office. Sometimes young men and women with disabilities are really resistant to getting shots or getting blood drawn, and sometimes they have to be restrained or held down, or even sedated to like go to the dentist. And then we're starting to think more, maybe the medical power of attorney may not be the best way. It depends on just how significant that is, or if they have very significant medical challenges, where surgeries may be required and things like that, then we're kind of maybe leaning more towards the guardianship side. So the level of capacity that a person needs to have to sign a power of attorney is they need to understand the authority that they're giving someone. They don't have to be able to read the document. They don't have to have a long conversation with me about, medical powers of attorney or durable general power of attorney or their agency relationship or all that. They really just need to understand the authority that they're giving someone. And it's up to the professional, the attorney that's working with family, to kind of ascertain whether or not their clients have that. And since I work solely with adult children with disabilities and their family, I like to find that level of capacity whenever it would work, whenever it would make sense. Because otherwise we'd be doing way too many guardianships. And I do believe that the General Assembly, that's what they want us to do. So in some cases, it's enough for me to, when I'm talking with a young man or woman, to just ask them, tell them about it, but, does this sound good? Is this what you want your mom and dad to be able to do for you? Do you want them to act as your agents and make medical appointments? And they say yes, and that's enough in most cases for me. And realistically, though, I don't think any young man or woman with disability really understands that concept completely. I think it's just weird to them, because that's what mom and dads are for. Of course, I want them to do that. But if you want me to sign a piece of paper that says that they can continue to do it, well, then, yeah, I'll do that, Mr. Attorney. I'll do that. But I think there's an element of that involved as well. So now, a medical power of attorney can also include a special powers for mental health treatment. And I would say, in my experience and my observation, is if a medical power of attorney is going to fail, it's going to be on the mental health side of things. When somebody needs inpatient mental health treatment and they don't want to go, you can have special powers that you can get them into the facility when it's clear that they're having a mental health crisis. You can sign them in even against their will, isn't that? But the problem where the medical power of attorney, in my experience, will fail is 3 or 4 days later, after they've been treated, they're starting to regain their capacity, and the hospital decides that, or the facility decides that they no longer meet the criteria there to stay in the hospital and they want to discharge. And parents will often say, well, not yet. He's not ready. He needs more time, or she needs more time. But the power of attorney doesn't give you the authority to override what, your son or daughter signing themselves out. And I've had that happen twice last year. First 2 times it ever happened, perhaps because we were pushing the power of attorney a little bit more. But just to put things into context, what we did then is we did go do guardianship. So just because we start with a less restrictive alternative like powers of attorney doesn't mean that we can't do a guardianship later if that level of authority is actually needed. And in those 2 cases it was. In fact, that's the only 2 times in 10 years I've been doing this that I've had to do that. And both were for significant mental health treatment concerns or issues. We're talking more along the lines of schizophrenia, hearing voices, and being unable, when you're in that situation, to make any kind of medical decision for themselves. So, like I said, we did guardianships for that. But to reverse that whole line of thinking is when a young man or woman's 18 and I think they have the capacity to sign a power of attorney, and talking with parents, we decide that's the best way to go. If we think it's good at 18, for most of them, the vast majority of them, it's going to be good at 19, 20, because you're 22, 26, because your son or daughter is going to continue to develop at their own pace. My daughter at 26 can do things now that I never thought she'd be able to do at 18. And so if the power of attorney works when they're 18, it'll absolutely work as they get older. And a nice thing about it, too, is with powers of attorney, since they don't lose their rights, you continue to work with them to be as independent as possible. They can make their own medical appointments. They can fill their own prescriptions. Not saying that you necessarily couldn't do that under a guardianship, too, but I like the powers of attorney when they work. So you can move to the next slide. Sorry, I should have sent you the actual PowerPoint. It's not lining up page-wise either. So we talked about power of attorney for education. Oh, and as far as for medical, even though the durable general power of attorney is for finances, Social Security Administration doesn't use powers of attorney or guardianships or conservatorships. They use their representative payee program. So either with a guardianship or without a guardianship, when your son or daughter becomes eligible for SSI, you're likely to become their representative payee, and you'll be managing their primary source of income. So, guardianship. I think from what I'm saying is if you can move down just a little bit more, there we go, perfect. So, there's in Virginia, guardianship and conservatorships, excuse me, are like flip sides of a coin. Guardianship's over the person. You make medical decisions, decisions about where to live, educational decisions, all the kind of personal decisions, but not financial. That's in conservatorship in Virginia. The process is the same for both. But I don't do very many conservatorships, and we'll talk about that in just a second. But guardianship is a process in a local circuit court. You file a petition asking the judge to appoint a guardian for somebody, or co-guardian, so more than one person can be guardian at the same time. And you can also ask the judge to appoint a standby guardian. Standby guardian is someone that does nothing while you're living, but would step into your shoes if something happens to you. And as part of the process, the judge will appoint a guardian ad litem. It's another attorney that's trained to work with adults that are allegedly incapacitated. Guardian ad litem's job is to be a neutral third party, to represent the person's best interests. Meet everyone, meet their client, I was going to say their client, but it's not actually their client. Meet the person, look at the medical reports, and then file a report with the judge. Does the person need a guardianship? Are the proposed guardians suitable? Is a standby guardian suitable? And why less restrictive alternatives like powers of attorney won't work? So they do have to, that's a 2 years ago change where the guardian ad litem actually has to say in their report, and I've had one case so far where a guardian ad litem came back and said, Matt, why aren't we doing powers of attorney? Because that's what I'm thinking I'm going to recommend. And what we did in that case, that guardianship case, is we withdrew the petition for guardianship and we went with powers of attorney, knowing that if we need to, we can go back in and do a guardianship later. And at that point, if we have to do it, there's going to be a reason. Either the power of attorney failed or something happened, and we can say, Judge, we tried that. And I don't think we'll get there in that particular case. I think powers of attorney will work, but it kind of shows the interplay between the two. So in a guardianship, there's also medical reports are filed. There's a hearing. You schedule it. You go before the judge. Once the judge signs the order, then the guardians, newly appointed guardians, would have all the legal authority to make decisions for their son or daughter. But as a part of that process, though, your son or daughter will lose those rights. They'll lose the rights to make their own medical decisions, to make their own educational decisions, to make their own decisions about where to live. They'll lose the right to drive, the right to vote, although those are two rights that I can sometimes get a court or judge to allow a young man or woman to retain. They'll lose the right to marry, the right to sign contracts, the right to possess a firearm. So in many ways, a guardianship is like resetting the parent-adult-child relationship back to parent-child. When your son or daughter is 17 and a half, they don't have those rights. At 18, the law says they do. Guardianship is just resetting it as if they're 17 and a half again. Now, rights can be restored. So even if somebody does lose the right to drive, for example, 6 years later, they passed the learner's permit test. They're maybe slated to go to WWRC for the driving course. And they need to be able to be eligible, have the right to drive to get their learner's permit. You can go back to court and say, hey, judge, things are looking great. Will you sign this order restoring the right to drive? And I've done that a number of times, and that's really fast. And, well, I don't want to say fast because you still have to set a hearing, but it's easy, it's straightforward. You can restore all of a person's rights too, but that doesn't happen as often as perhaps the General Assembly would like, because in my experience, once parents have a guardianship in place, you set up the standby, you've got it all secured, and why then go back in later and change that? And there's also some practical reasons too, or at least one practical reason. As we age, even though we plateau in our ability, everyone does, capacity to make decisions, and as we age, we start losing that a little bit, slowly degrades. And with a young man or woman with disability, even when they get older, guardianship is kind of more in play then too, especially since it sets up the standby guardian. But it doesn't have to be that way. There are things like limited guardianships, at least Virginia code allows for them. I've only done one, and I'm looking at doing some more maybe in the future. But the problem with a limited guardianship is the decision making that we talked about, like medical decisions. There is no good way to limit a guardian's authority to make medical decisions. That would actually work when the doctor reads it. Like, wait a second, what? So if it's an easy decision, their child gets to make it, and if it's a hard decision, they get to make it. So it's really kind of all or nothing in many of those decisions. The reason I'm looking at doing more of the uh, perhaps limited guardianships, and that would be more applicable in that mental health category, because somebody that has schizophrenia, for example, when they're cycling down, they don't have capacity. It's clear they don't have capacity, and they need a guardian. Because, like I said, powers of attorney don't quite get there. But when they're on their meds and everything's going well, they have capacity. So, it, and capacity then to say maybe decisions of where they work and where they live and things like that. So I can see kind of crafting out a more limited order for those situations. Now, on the conservatorship side, which is finances, I think limited is actually easier. I've talked to a lot of other attorneys that do that, especially for elder law. So if you could consider the case, because the process we're talking about here is the same no matter if you're 18 or 85. Case of an 85-year-old who is really no longer able to manage all of their investments, but they can manage a checking account and they can pay for things. So you can see that in a conservatorship, you can say, well, the conservator has control over these assets, but you have control over these. So you can I think there's more opportunity for limited. The reason I don't do very many conservatorships, and I don't recommend it in most cases when we're doing a guardianship for a young adult, is it's not needed. A young adult's primary source of income is typically SSI, and you become representative pay because the Social Security Administration does not use guardianships or conservatorships. They have that representative payee program. And they don't have a lot of assets, so we're not talking about managing all these investments. And conservatorships come with reportings to the Commissioner of Accounts. So it's like being an endless probate where you have an inventory and then the annual accountings of how the money's spent. Now those accountings, to be fair, can go every 3 years. They can, if the expenses are less, if the person's getting Medicaid, and you don't have to necessarily account for the money that you're managing as a representative payee. Some commissioners of account will waive those as well, but why add in all this reporting and fees if you don't need the authority? Um, so don't do a lot of conservatorships. When I do it, then reasons why I would do a conservatorship. Let's say, for example, a young man or woman who's getting SSI, Medicaid, and Medicaid waiver services, and so those all have a $2,000 accountable resource limit. If they get a direct inheritance and they're under a guardianship, so if they don't have the capacity to sign that money over to like a trust, then we have to do a conservatorship, appoint somebody to do that so we can get it into a trust so that it doesn't affect their benefits. They maintain their benefits. And then as soon as we're done with that, we close the conservatorship, because why continue doing that? So you go to the next page, please. So guardianships are also, guardians make decisions for a person, but they also are in a little bit better position to protect a person, in my opinion. And conservatorship, same thing. So I could see it for an elderly person, if your money is being managed by a conservator, then you don't have to worry about fraud. Now that I brought up the topic, I don't usually talk about that. A lot of parents worry about that their children will become um, victims or of financial fraud, and I don't see that. I don't see very much of it at all. Actually, I haven't seen it with any of them. I had one client that had a card issued to her from BJ's store and ran up like $1,500 on it. The only reason I think she got it is because she was on the account when her mother was still alive. So they didn't even think about vetting to see if she had any income. And that's the reason why I don't think, though, that young men and women with disabilities are targets, because they don't have any money. There's no money there. Their SSI is managed by a representative payee, and so I just don't see that. There are some things, though, since I'm on the topic, I'll finish it, that you can do if you're still worried about that. Even if you go with powers of attorney, power of attorney would give you the authority to unwind an unwise transaction. You can, if you're worried about financial fraud, you can put a freeze on their social security numbers, so that with the three rating agencies, so that anybody trying to get a credit card in their name is going to come up against that hard freeze on any kind of credit checks. But then again, any kind of request or application for credit is going to be denied because they don't have a credit rating. So anyway, but there are things you can do. If they have a debit card, you can have it so that it texts you every time it's used, and you can kind of watch and see. I do that with my card so that I know when it's a little annoying when I do get gas, it texts me, it says, hey, there was an expenditure, but it's really helpful later on when I get that email saying, oh, your card has been for this $2,000. Call here and do this stuff. And I was like, no, it hasn't. I haven't gotten a text. So if we slide the slides down just a little bit more, I did talk about how the Virginia General Assembly has been making annual changes to the Virginia Code, and it's been the last 5 years. I've got 2023 up there, but 2024 there's also been one kind of significant change. We'll talk about that. So the whole gist of this process is that General Assembly is really trying to put in more checks and balances in the guardianship process to make sure that it's only being done when it's really needed. From a parental standpoint, you just want to make decisions for your child, and they can't, so why are you making it harder for us? And I get that, but I can also see the General Assembly's point, because what we're doing in essence from a state perspective is Virginia Circuit Court judge is actually taking away somebody's rights and saying, you do it instead. And when the judge does that, it's a state action, and we really should be very careful when that's happening, and I appreciate that. So one of the requirements that we talked about already is that guardian ad litems are responsible for saying why less restrictive alternatives wouldn't work. They also have to review IEPs now. And there's other things that they have to do in their reports. Keep adding to that guardian ad litem report. Judges are now supposed to set a schedule of review hearings. So you have a hearing date for the guardianship, guardians are appointed, and then the judge is supposed to set a review hearing about a year later. And then they can keep those review hearings going. It can be every year, or it can be every 3 years. So set a schedule for those. Now, that can be waived. And all but a very few, a small handful of my cases, the judges will waive that review hearing because, like my typical client, are parents for an adult child with a lifelong disability. And those review hearings don't make sense because, if your child needs a guardianship at 18, they're going to still need it at 19, at 20, and having parents come back in a year later just to say everything's going fine is really kind of not necessary. It's also General Assembly's clarified about restricting visitation with the respondent. That one really hasn't come up in any of my cases right now, but there is now a process for that. The recent change this last July, is that the respondent, that's the young man or woman, or the elderly person, it doesn't really matter their age, but that's the person that needs the guardianship. That's in the context of a guardianship case, they're the respondent. And they have the right now to ask the judge to review their guardianship at any time with a simple writing. It can be an email. It can be just a letter to the judge, and the judge then will take a look at it and can open up the case again. And I think that one really, that kind of is like the icing on the cake for me as far as the General Assembly's intent, making it more difficult, looking at less restrictive alternatives, and then giving a very easy way for a person under a guardianship to say, hey, I want to review, or I don't want this anymore, or whatever the case may be. Now, in my cases, that isn't going to ever be an issue. I don't see that happening because when I'm doing a guardianship, the respondent is typically nonverbal or minimally verbal, because we talked about powers of attorney and that the capacity to sign one is that they have to understand the authority that they're giving somebody, but they have to also be able to communicate that understanding to me in some fashion. So in all but just a very small handful of cases, if a young man or woman is minimally verbal or nonverbal, they don't have the capacity to sign it. Even if I think that all of my clients understand more than they can communicate, but in even those cases, if they can't communicate it to me, then I really can't say they have the capacity to sign a power of attorney, and that's guardianship is the last resort. The cases where they've been primarily nonverbal and I've done powers of attorney is they are able to communicate with a device. And that's typically more on the cerebral palsy side of things, or with that particular diagnosis or disability. So if you could go just a little further down on the screen. Required visitation. So that's another one. This one isn't really meant for parents because they typically, when their son or daughter is younger, they live with them. But if they live in a group home or in sponsored residential setting, they are now required to visit once every 3 months, 4 months, once every 120 days, 3 times a year. At least one of them has to be in person. For parents, though, they always meet this requirement because they're always visiting. They're always taking the kids out. So this, I think, visitation requirement is more specifically focused at like attorneys that may be guardians for a number of people, or public guardians. But public guardians already had this, so it's really for professional attorneys, professional guardians, if you will. So if we go down a little bit more, we can talk about some of the duties of the guardian. So the primary duty of a guardian is to make decisions for a person. They don't have to provide direct care. They don't have to live with the person. They have to be available to make decisions. And then this primary decisions that a guardian makes are medical decisions and decisions about where to live. That's something to consider too. If you are doing a guardianship and you're asking for the court to appoint standby guardians, and that standby guardian is often an elder sibling, I think it might be daunting to them. It's like, oh gosh, I got to do all this that you do. That's not necessarily the case. They just need to be available to make decisions. They don't even have to be in the same state. They can be out of state to do that. Just be available to make decisions. Check in on them. Make sure everything's going right. Well, and if you find things, though, however, if you find things that you don't like, you go, perhaps to their group home, and it's like, oh wait, I don't kind of like this, and you can address them or you can move them. That's kind of the decision making that you have as a guardian. There's an annual report that guardians file. It goes to the local Department of Social Services with a $5 filing fee. The guardian is not liable for the acts of the person, the ward, unless they're personally negligent. There's no case law to describe what that means. I use the example of that, if you take them out to a store and there's an episode and they damage something or maybe injure somebody accidentally, no negligence. Second time it happens, maybe. Third, fourth, fifth time, then there might be some negligence there, only because you should kind of understand that maybe going to that store, there's a trigger for them. Guardians don't have to expend their personal funds. And this last one, a guardian's duties and authority shall not extend to decisions addressed in a valid advance directive or durable power of attorney. So there are cases where somebody may have both. That's more in the realm of an elderly person that may have signed power of attorney in an advance directive, but then there's a needed conservatorship is still needed. I don't do elder law, but I could imagine where a case where if somebody doesn't like how the medical decisions are being made to agents, they don't like the agent and how they're doing their job, they could also try to get a guardianship or conservatorship, and that opens up a little bit of an extended battle, which is a good point to think about. So guardianships are a case in the circuit court. The respondent has the right to an attorney, so I made a distinction there saying the guardian ad litem isn't their attorney, but if they want one, they don't have the money to pay for one, the judge will appoint an attorney for them. And they have a right to a jury. And a contested guardianship case where there's multiple parties where, say, for example, let's use an elderly person, two of the children don't agree who should be guardian or conservator because there's money involved, and they have attorneys, there's a guardian ad litem, and the elderly person might say, heck with this, I don't want it, and they have their own attorney. It could be a 2 or 3 day trial where you're putting on evidence, evidentiary, documentary evidence, witness testimony, and so that is not my experience because I work with young adults with disabilities and their families. Our hearings are all uncontested, and they're less than 5 minutes because it's very straightforward. Judge reads everything that's been filed beforehand and has already made their decision. And in many ways, when we're talking about a young man or woman who parents or family members are being guardians, it's administrative. Judge is signing a piece of paper that allows the guardians to continue doing what they have been doing and what needs to be done. So, scroll down just a little bit more, please. So, a guardian, just because you've been appointed as guardian, it doesn't really change how you work with your son or daughter. If they can make a decision, if they understand it enough, you go with what they want. If you can help them to become able to participate more in their decision making, that's great. If they want to sign something, sign off on their IEP, they can do so. It's just legally, it's the guardian's signature and the guardian's decision that is the operating action. But doesn't change how we work with our children, even if they're under a guardianship. So let's skip the questions. So if you would go down a little bit. So at the end, we will have time for some questions. I'll try to wrap this up a little bit more quickly. And but since we're recording, then this way we do the questions after the recording. So quickly, disability benefits. There's 3 that I want to talk about. SSI, SSDI, and childhood disability benefits, I need to change the slide. It's actually been renamed, and the name is better because it's more descriptive of what it is. It's not about when you're a child, it's about an adult child. And now it's called the Disabled Adult Child Benefit, DAC, Disabled Adult Child. So SSI, I think most of you have heard about it. I'd be surprised if you haven't. It's for persons with can we move the slide down a little bit? We'll pass up the healthcare part. I'm going to try to buzz through this a little more quickly. And a little bit further, please. At least from what I'm saying. There we go. All right. SSI is a federal benefit meant to help pay for room and board for persons with disability or blindness or over the age of 65 that have low income and low assets. Income limit is SGA in 2024 is $1,550. And when I say SGA, that's substantial gainful activity. To be eligible for SSI or SSDI for that matter, it doesn't mean you can't work. It's that you're unable to perform substantial gainful activity. It's a defined term. And one of those definitions of SGA is whether or not a person makes more than $1,550 a month. If they make more than that, they're likely not disabled, no matter how disabled they may be. But if it's less, then you meet the income requirement for disability benefits. Accountable resource benefit limit is $2,000. And while a child is under the age of 18, parents' income and assets are deemed to be theirs. So that often makes them ineligible for SSI. But when they turn 18, it's just the child's income and just the child's assets. So as long as they are have less than $2,000 in countable resources, they meet the financial requirements. So for applying for SSI, you can do that a couple different ways. You can go online and do it. You can call the Social Security Administration and have set up an appointment either in person or over the phone. If you do the appointment route, your son or daughter is likely going to have to participate in that conversation, at least to say, I want my mom to do it or I want my dad to do it. Because you're applying after they turn 18 and they have the rights. And Social Security Administration, remember, again, they don't use powers of attorney and so forth. If you're under a guardianship, if you got the guardianship done by that point, they will recognize that and let the guardian talk. But even then, once the benefits have been approved, they still appoint a representative payee, and it's really your role as a representative payee that allows you to talk for your son or daughter. SSI is, since it's meant to pay for room and board, and I keep saying board, they recently took food out of that consideration. So it's meant to pay for living arrangements. If your child's living in your home and not paying their fair share for living arrangements, then there's a 1/3 reduction rule that kicks in, because that living in your home and not paying their fair share is a type of unearned income called in-kind support and maintenance. So all these stupid little rules with SSI and Medicaid that come into play to make it more difficult. But so you want to charge them for their fair share of living arrangements. And a little bit about work. SSI will be reduced with earned income, but the takeaway from this very brief presentation is that your son or daughter will always make more money if they're working, even though their SSI is reduced, because there are work incentives that come into play to reduce the effects. First $20 don't count for the general income exclusion. There's $65 for earned income exclusion. If no other work incentives apply, they take the half of the remaining amount of money for that month, earned income for that month, and that's how much SSI will be reduced. So you can see they'll always make more money. So if we go down to the next slide, SSDI. Unfortunately, it has a very similar acronym, but it's completely different. It's a Social Security Disability Insurance. It's paid for through our payroll taxes when we work. Can a young man or woman be able to get this? Yes, absolutely. So they get SSI when they turn 18, they finish school, 21, 22, they have their SSI still going, they get a part-time job. After 3-4 years of actually quite minimal part-time work, a young man or woman can start drawing SSDI off of their own work record. And for SSI purposes, remember, stupid little rules, it counts as unearned income. So it doesn't necessarily result in any more money, any more benefits. And I've got a slide that'll show that here a little bit. So if you make $200 of SSDI, it reduces SSI by $180 because of the general income exclusion, but it reduces your SSI. But it also comes with Medicare. So for those young men and women that are able to work, there's a sweet spot of working part-time. There you get SSDI off of their own work record. They've got Medicare. They keep their Medicaid waiver services, and their SSI will gradually just get lower and lower and lower as their SSDI goes up. And so they'd be eligible for quite a few different benefits. This is supposed to happen automatically when they reach the work credits available, but it's always best to call the Social Security Administration and say, hey, they've been working for 3 years now. When we talk about SSDI, because you want to try to make that transition, in my opinion, more smooth. They don't catch it. 6 months later than they do, and you get conflicting letters. You get one saying that they're no longer eligible for this, or their benefit is reduced, and that's the SSI one, and you owe back this money. Then you get a week later, you get the SSDI letter, say, hey, there's a new benefit, and here's a back benefit, and it just can be really confusing. But if we go to the next one, we'll talk briefly about the disabled adult child benefit. I think I have it right on this one. Yes, I do, right here. Okay. So this is often known as SSDI off of a parent's work record. And that kind of makes sense because it's like that, but it's for an adult child who's been deemed to be disabled before the age of 22. When a parent passes away or a parent retires and starts drawing Social Security, or when a parent becomes disabled and starts drawing SSDI themselves, the adult child then can draw a benefit off of the parent's work record. That amount depends on the parent's work record, but it's often in the $1,400 to $1,800 a month range. It wipes SSI out, but that's okay. And it's sometimes actually reduced. That $1,400 to $1,800 will go up to like $2,400, depending on the parent's work record when the parent eventually passes. So if you retire, there's a limit to how many people, not how many people necessarily can draw benefits off of a retiree, but there's a maximum family cap of how much the family can draw, and you run into that cap. So sometimes the child's disabled adult child benefit will be reduced, but then when the parent passes, it goes up. And they don't have to be working to do this. So it could be very well that if the young man or woman is disabled to such an extent that you're just getting SSI with no work and no SSDI, they still get the disabled adult child benefit when the parent passes. And it comes with Medicare also. So for most of my clients, their long-term medical insurance is going to be Medicare. Medicaid is secondary. If they also have military benefits, TRICARE comes in. It's in the middle there. But eventually Medicare will be the primary medical insurance for most young men and women with a disability, if they're getting disability benefits. So there's another slide next that shows kind of how that looks like. So first part is SSI only. Max benefit this year is $943. Next year it goes to $967. SSI and part-time work, like I said, they'll always make more money working even though their SSI is reduced. SSI, part-time work, and SSDI, as they've got enough work credits to start getting SSDI off of their own work record, you'll see that it's really no difference. It's $20 difference, that's it. But then part-time work and the disabled adult child benefit, or if they're not able to work, just get rid of that green part, the disabled adult child benefit, which is more than SSI. So their benefits will change over time based on the family situation. So if you would please just scroll through the Medicaid and Medicare all the way down to Special Needs Trust. It's like one of the last. Right. So I'll talk briefly about Medicaid. Medicaid is meant to help. It's not insurance. It helps pay medical expenses for persons with low income and low assets. Medicare is much better. It's paid for through our payroll taxes. All of our seniors rely on it. Most doctors take it. And so eventually your children will likely get it as well, either because they work themselves or later when you retire and start drawing Social Security, they'll get that disabled adult child benefit and they'll get Medicare with that. So finally, just planting a seed here in the last 2 minutes or so. We talked a lot about the $2,000 countable resource limit for SSI, Medicaid, and don't forget about Medicaid waiver services. The waiver services are part of Medicaid's long-term care. Instead of accessing it in a nursing home, you get services to help your son or daughter live and work in the community as independently as possible. So you DD waiver for those that have more of a medical need. There's a CCC plus waiver, but those really are, the waiver services are a very important benefit. If you don't have them, if you're not on the DD waiver list, waiting list, and you're uncertain, it's the local community service board that is the gatekeeper for that, and DSS for the CCC plus waiver. So anyway, since those all have a $2,000 countable resource limit, the way to leave an inheritance for your son or daughter's benefit is to create a third-party special needs trust. And that way you can direct the inheritance that you want to leave to them to the trust instead of to them directly. And the trustee manages it. We have one typically the trust sits empty, unfunded while you're living. It's an empty bucket waiting to be filled when you pass away. And it's filled then with by your wills and beneficiary designations, some like life insurance, IRAs, and investment accounts. So we have a trust for my daughter. My will and beneficiary designations, I'll say everything to my wife. She's my primary beneficiary. But if she's no longer living, then half to my son, who's typically developing, and half to my daughter's trust. So it goes into her trust. It's never hers. So it doesn't count against that $2,000 countable resource limit. And then the trustees, the successor trustees that we've named in the trust agreement, will manage that. They can invest it and use income and even some of the principal, if need be, to help pay for things that my daughter's benefits aren't paying for. And so from a financial standpoint, it gives me a lot of comfort knowing that that money is there after I pass for her. Trusts can own anything that a person can own. Any kind of, it's a separate legal entity, and it can own like stocks, bonds, mutual funds. You can have an investment account with Schwab and then have a bank account at Wells Fargo. It's all titled in the name of the trust. It has its own tax ID number, and it generates income on those investments. That's a third-party trust we're talking about. The other type of trust that is on the next slide, and you can get copies of these slides. I can send it to you, or so can facilitators here today. The first-party trust, that's the kind of trust you have to use to requalify or protect somebody's benefit if they have assets or if they get a direct inheritance. And I don't like doing those. Those have a Medicaid payback clause, meaning any money left in that particular kind of trust has to go back to the state when the beneficiary passes to reimburse it for Medicaid expenses on that person's behalf. Third-party trust doesn't have that. It was never theirs to begin with. It goes into the trust. It's used during their lifetimes, and when they pass away, it'll go to their kids. Typically, it goes to whomever it says in the trust agreement, but typically that would be their children if they have any. My daughter, I don't think she will. And if she doesn't have children, then it would go to her brother and his family. So it stays in the family. Two ways to do a third-party trust. You can either have an attorney write it, and then write it, work together with an attorney. I would call that more like a standalone trust. Or you can do it through either the ARC in Northern Virginia or Commonwealth Community Trust, two nonprofit organizations in the state of Virginia that run pooled trusts, where you create a sub-account under the master trust agreement. The benefits of those is they're less expensive than typical attorney's fees, although my fees are lower, but what's beside the point. They're less expensive, and for families, small families, where you don't have somebody that's readily available to be that successor trustee, especially from a younger generation, because our children are likely going to outlive us. The ARC, for example, would be the trust administrator. They have a key bank as their trustee that manages and invests the money, and it makes it a lot more simple for the people that are going to be doing this for your son or daughter after you pass. So somebody's still going to be there, saying, can trust pay for this vacation? Can it pay for, own a car? We need to buy a car, especially modified for transportation. Will the trust purchase that? Yes. Or they may look at it and say, well, there's only $60,000 left in the trust, and you want to buy a $40,000 sports car? Yeah, I don't think so. No, we're not doing that. But anyway, so eventually you'll want to look at doing a third-party special needs trust and some estate planning, just so that you can leave money as an inheritance for your son or daughter without messing up their benefits, and have somebody else manage it for them. Last thought on that is the managing it for them is, my daughter is fairly high functioning. We have powers of attorney for her. They work great. She has shown the ability to live independently with some supports. But she has a really hard time saying no if a friend or boyfriend is asking for money. Having it in the trust and protected that way also gives me a lot of comfort. So that's all I've got. That was the presentation today, and I guess we'll open it up for questions.